beide Tage.
Good morning and welcome to this week's edition of Chaile. I'm sitting here at Starbucks doing my final preparations for a CCMA case a little bit later today. And I also have a bit of a flu, so pardon my deep, sexy voice. Yeah, so this week I've been involved in quite a challenging negotiation between an employer and a dismissed employee who now filed a dismissal dispute and an unfair labor practice suspension dispute at the CCMA. So I want to talk about this week of when negotiation turns personal. That's right, when negotiation turns personal. So imagine you are dismissed from your job, and instead of walking away quietly, you demand a year's salary, compensation of 12 months. You are convinced as an employee that the law is on your side, but is it really? Is the law really on your side? Okay, so let me just explain this situation. It's quite a challenging negotiation. So far, no settlement. Didn't go well from a negotiation perspective. So, okay, this employer is a very small company, okay? And this employee is a general manager in the business, and a number of staff submitted grievances against this employee, specifically relating to abusive conduct, workplace bullying, harassment, typically creating or be responsible for creating a toxic work environment. And as you probably will agree with me, I believe sincerely, probably among the many problems we have in workplaces, the number one problem really is toxic workplaces, toxicity in the workplace. So the employee submitted grievances, and an independent investigator was appointed and interviewed all the staff, interviewed the employee involved, the alleged accused, if you want to put it that way. And objectively, there is quite psychological trauma in the workplace, like in serious. There's been a huge disruption in the workplace. Now, you can appreciate that a small employer cannot really accommodate for that. And also, I suppose, there's also been annexed into the amendment to Schedule 8 that is now effective from the 1st of September 2025, which sort of accommodates small employers who cannot afford this kind of disruptive conduct in the workplace. But anyway, so the employee was subsequently suspended on a precautionary suspension on full pay pending further investigations and have been subjected to a disciplinary hearing. So the dispute itself, okay, so in the meantime, the employee filed an unfair labor practice dispute, and after filing the dispute, actually after we had our conciliation this week, the employee was now officially dismissed because he was also subsequently subjected to a disciplinary hearing. Before conciliation, the employer tried to negotiate a settlement with her, extremely aggressive, just not interested to budge. She wants 12 months compensation. Okay, so I approached her conciliation. Man, she gave me gas. She doesn't want to budge. I did manage eventually to bring her down from 12 months to 6 months. Company being a small employer offered 2 months, but she made a loan to purchase a vehicle, and there's quite a high amount outstanding on this vehicle, so the company was willing to also write off the outstanding amount. And on this, the employee got quite aggressive with me because she didn't understand why I was talking about the vehicle. After conciliation, the very next day, I also set up a private Zoom meeting with her, which was really much more cordial. But when I started talking with the car, yes, I really pressed the button for some reason, and she became agitated again, and she didn't understand why I'm talking about the car because the car is hers. But what she doesn't understand is, in terms of the agreement, the moment she exits the business, the full amount becomes payable and due immediately. So technically, and everything, the full outstanding amount can be deducted from her last pay. She agreed and signed to that, but there's not enough money to do that in the kitty that she has left. Um, so technically, she's in breach of this loan agreement, and she doesn't understand this. There's so much aggression and emotion. I've explained to her. Look, at the end of the day, I can appreciate that you really dependent on this vehicle, but the employer is probably going to sue you if you're in breach of this agreement. Doesn't see it, eh? Amazing. So the unfair labor practice dispute for unfair suspension didn't go anywhere. We did object against CONOP, so it was a conciliation. Nothing came from it. From a settlement perspective, I met with her the next day, much more cordial, doesn't want to budge. Um, Interesting thing is that in conciliation, she eventually dropped the requirement to 3 months. We were actually close, really close, you know. But then, no, she became aggressive, doesn't want to budge, nothing on the table in conciliation eventually. The next time I met with her, and then she said, now look, she had a discussion with a lawyer, and she's no longer interested in settling on 3 months, it will now be 6 months. Back to 6 months. The employer is not willing to do that. They're naturally a small employer. So I was quite interesting. I see actually there's quite a lot of people who are so emotional, employees now, specifically in my experience now, they become so aggressive that they've done their legal research on ChatGPT, I suppose, or Google, and then they come and they start quoting law. And then I'm just like, oh my goodness, where did this person get this law from? Then she quoted me suspension. Why she believed the suspension was unfair is because Schedule 8 of the Code of Good Practice very clearly states the procedure when you want to suspend somebody. And I'm like, the commissioner sat right next to her. She was just keeping a straight face. I'm like, well done, commissioner, because I'm sure inside herself she was laughing also. And I'm just like, honey, really? You misread Schedule 8. Schedule 8 is a procedures for a dismissal, not suspension. Fair procedure in terms of the old Code of Good Practice, Schedule 8.4, which by the way is now Schedule 8.11, explains the procedure an employer must follow when you dismiss somebody. It's like a bit of a tick box approach, you see. So she completely misread the book. I brought it to attention, but it's like she's not even embarrassed. She's like, no, I am right. I'm like, no, you're not. Yes, I am. Who are you to tell me? I'm like, oh my goodness, this is going to be a long conciliation. Anyway, she, even though she preempted that she will be dismissed, I knew that she would be, but um, there was no official dismissal notice at the time of conciliation yet, but she got it the next evening. That's right there. And she, in conciliation, also said that she, understanding the dismissal will be procedurally and substantively unfair. From a procedural perspective, because the chairperson who did the hearing didn't email her the hearing report, the company did. So what the company did is they emailed her the hearing report, which was a recommendation. Now, we don't have the authority to dismiss the employee. We, as chair people, we only make a recommendation. It's up to the employer to consider and then actually officially about the decision or not. So the employer eventually, after conciliation failed and the second round of negotiation failed, then sent a dismissal notice. But now our view is that the dismissal is procedurally unfair. Why? Because the chairperson didn't send the hearing report. I'm like, oh my goodness, where in Schedule A do you see that the chairperson must give you the hearing report, At the end of the day, it's the employer's prerogative. And just by the way, on this point, we actually lost an interesting CCMA case 3 months ago in East London CCMA, where the employer sent our hearing report, which is a recommendation to the employee, but they never actually uphold the decision and gave him communication that you are hereby dismissed. And months, 2 months later, he filed an unfair labor practice suspension dispute also, and he won the case. Now, unfortunately, the manager involved at that time passed away. So we don't have any evidence whether he actually enforced the recommendation or not. And Initially, you said, sorry, it's only a recommendation, there's no dismissal, so you won unfair suspension dispute. Anyway, so from a procedural perspective, that's her reason for why the dismissal is unfair. From a substantive perspective, and she does have a point here, this is where it becomes complicated in law. The employees, she wanted to call the employees for to testify on her behalf. But in writing, none of the employees were willing to testify on her behalf. The company actually asked the employees, will you be willing to come and testify? And according to them, they are so traumatized by her bullying that they just don't want to be part of the hearing. So the independent investigator did testify in terms of her findings because she had interviews with the employees and the alleged accused. And in the hearing, the employee obviously claimed that she can't really respond because her accusers is not present at the hearing and she's got a right to face her accusers, which is right. So there's an element of hearsay evidence here. So that is the challenges in terms of the dispute. So now she's going to file an unfair dismissal dispute, and then she's going to consolidate the dispute into one, and we'll take it from there. So, but okay, so what does the law say? Well, the issue here is, as a starting off point, is Section 60 of the Employment Equity Act. That exposes employers to legal liability should it fail to act on concerns report for which an employee may have made him or herself guilty of harassment or bullying in the workplace. Section 60 reads as follows: liability of employers. 60, subsection 2. The employer must consult all relevant parties and must take the necessary steps to eliminate the alleged conduct and comply with the provisions of this Act. Subsection 3. If the employer fails to take the necessary steps referred to in subsection 2, and it's proof that the employee has contravened the relevant provision, um, the employer must be deemed also to have contravened that provision. So, if the employer don't take harassment in the workplace seriously, they can be sued. So the employer must act. They must deal with this. So, the legalities around suspension, now the courts have basically provided us with some guidance in this. There's no procedure in the LRA per se, how to deal with a suspension other than the unfair suspension in terms of Section 186, subsection 2. An employee can file an unfair labor practice dispute in this regard based on procedure and substance, I suppose. But the courts have given us some guidance that number one, there must be a prima facie case that the employee is guilty of gross misconduct. Prima facie means on the face of it, it seems like the employee is guilty of gross misconduct that probably may justify a dismissal. Number two, that there are reasonable grounds why the employee should be removed from the workplace. Maybe for the safety of people or to avoid further workplace conflict, or if the person can maybe intimidate witnesses or interfere with the investigation. So then there's a third point. The third point is that an employee must be allowed an opportunity to make representations why not to suspend. But that was in principle overruled by the Constitutional Court in 2019 in Long versus SAB, where the Constitutional Court said, listen, there's nothing in the law that suggests that the employee must be given opportunity to make representations before the person is suspended, unless if you have a policy in the workplace to that effect, or if there's a collective agreement in place. So that's why you'll probably see in government, if our president is suspended a minister, they will ask him to make representations why not to suspend, because it's part of the collective agreements, you see. And then, so I don't see prospects for her from the unfair labor practice suspension dispute on dismissal procedure, but substance. And this is a thing where she doesn't really appreciate. And I told this in conciliation, there's a legal sensitivity around this whole issue of hearsay evidence. Can you accept it or not? A lot of people say you can't, and in a way, correctly so, mostly you can't. But the Laws of Evidence Act does give us provisions to take into consideration when a decision maker can actually accept hearsay evidence. So, first of all, what is hearsay evidence in terms of this law? Just in a nutshell, it is when evidence is subject to the testimony of others. So even though the independent investigator, she has her direct evidence in terms of the outcomes of investigations and interviews with all involved, however, the report is still subject to the actual testimony of the individuals, which wasn't present in the hearing. So there is a point for her I'm not entirely, it's my opinion that um, I don't think she will win the case based on that argument alone. But this is one of those cases where you'll probably have a CCMA commissioner. We have our view. The commissioner may have a different view. We may have a Labour Court judge having a different view, and the um, Labour Appeal Court, I suppose, have their own view. So this kind of dispute is ripe to go all the way. So there will probably be a decade of litigation at great cost to both parties. So this case is ripe, for that kind of lengthy dispute. So anyway, so interesting is the Laws of Evidence Act basically say that in parties in a hearing upfront must disclose that there will be hearsay evidence that will be relied on and that all the parties must agree to the submission of hearsay evidence. But it also in section 3.1 subsection C give a consideration for decision makers, I suppose, when there are no agreement or so. And this section provides as follows. In exercising this consideration, section 3.1C requires consideration as follows: the nature of the proceedings, the nature of the evidence, the purpose of which the evidence is tendered, the probative value of the evidence, the reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, and any prejudice to a party which the admission of such evidence might entail, and any other factor which should, in the opinion of the court, be taken into consideration. Is of the opinion that such evidence should be admitted in the interest of justice. If it's basically in the interest of justice to accept hearsay evidence, then a decision maker can. So in our case, the nature of the proceedings, we're talking about a labor dispute in terms of a disciplinary hearing. The nature of the evidence is really the testimony of grievances submitted by employees. Now there are grievance letters, there's the feedback from the private investigator or the independent HR investigator. Um, the purpose of rendering this evidence or tendering this evidence, obviously, is to create a safe work environment, to eliminate harassment in the workplace bullying, and discharging the onus on the employer to create a safe work environment. And you can't just not do anything about this, you see. And then obviously to test whether the employee or the accused is actually guilty of this and to find a remedy for this. The reason why the evidence is not given by the person, okay, on whose credibility this is relying on, well, in this case, I can't really venture too much in the effect of the psychological trauma. It does seem that it had some quite dramatic impact, so it seems like there's a good case there. And any prejudice to a party, now, the accused may feel she was prejudiced in a way that is true, but I also feel that the independent consultant interviewed her and others, so she's got good evidence based on the versions of everybody involved, including herself, and she had an opportunity to rebut that, and she actually didn't do that. She just basically said, you know what, my accusers aren't here, I can't really defend myself. She didn't approach that from a good faith perspective. I think she could have done a lot with the evidence that was actually presented to her. She could have denied it. Okay, she did deny it, but I mean, she could have collaborated a little bit more, ventured a bit more into detail, and tried to explain herself and give some context. No, it wasn't done in good faith, you see. So that is a part of the legal issues. Now, how will this dispute typically look like moving forward? And this is sort of the crux of the situation here. So the CCMA, they will probably apply to have the two disputes consolidated. She's now also talking about the defamation of character civil lawsuit, So she's like completely emotional. Um, I suppose there could be potential Labour Court reviews and appeals at the Labour Appeal Court, which will probably turn around this whole issue of hearsay evidence. Can it be used? Can I dare say that this may become a constitutional issue? I personally don't think so. I think, the matter's been dealt with already. But who knows. So, but as I said, this case is right to go become a lengthy dispute and litigation. But at the end of the day, this case is a classic example of when emotions, pride, and poor legal understanding collide in dispute resolution. Um, so the question is, should the employee leave quietly? Not necessarily, okay? Um, but I do believe now, if you look at a good settlement, there's a saying, a good settlement is when both parties hurts. The one doesn't want to give anything but has to. The other one wants everything, the whole world, but doesn't get it. And obviously, parties must appreciate that when you come into dispute resolution, you must have an open mind. I think the employer had an open mind to a limited extent, but that's also, have to take the context of into consideration. Like it's a small company, man, they don't have a lot of money. But the employee is closed. Her mind is not open whatsoever. And she's not appreciating the fact that she doesn't have the resources, the funding to go all the way, should this go to the highest courts. And I do think the settlement is probably fair, not exactly what she's looking for. And another thing is employees often look at this from their own interest perspective only. I have bills, I have this, I have that. But when it comes to dispute resolution, it's also about the employer. So you need to be open minded and look at this objectively. And I know it's very difficult. So I've got a final quote, okay? In labor disputes, the smartest person in the room is rarely the loudest. It's the one who sees both sides and know when to walk away. See you next week. Enjoy. Bye-bye.
Good morning, Harmony people. Let's have a look at some of the vacancies posted nationwide on our Harmony People's Network this week. First up, the well-established multinational financial services business is seeking a highly skilled and proactive IT security engineer with minimum 6+ years of IT security engineering experience. Kista is advertising on behalf of a client. They are looking for an operations manager. In Cape Town, there is an opportunity for a senior business analyst, and Eve Recruitment has an opening for a junior accountant. For the full information of the mentioned positions, how to apply, as well as more available positions, find the vacancy link in the description. You will also find a link to a useful video on how to compose a winning CV and have a successful interview. Tune in again next week for more Harmony vacancies.